So, new workplace laws for 2026. I've been an attorney in Illinois since 2008. Um, I've seen a lot of years where it's really kind of ugly with what they do. This wasn't really a bad year as far as it goes. I think last year when I did this, there was a lot. And a couple years ago, well, it's awful. Um, Illinois, in my opinion, not one of the better places to be an employer. It's very employee friendly, very union friendly. And so you do tend to get a lot of these. But again, this year wasn't really too bad. It seemed like it was more kind of cleaning up things that were in existence already, as opposed to a whole bunch of new stuff that everybody kind of had to adjust with. So, in my opinion, because I deal with this a lot in terms of employment agreements, one of the bigger changes, and it's really kind of subtle, was to the Illinois Workplace Transparency Act. And this is an act that governs employment agreements and separation agreements, severance agreements, all of those different things. So this particular amendment became effective in January. It's in January 1st. To the extent that the slide on here doesn't have a date on it, the effective date is January 1st. I think there's only one law. I think it's the neonatal law that goes into effect June 1st. Everything is kind of already been in place a little bit. So the Workplace Transparency Act provides a contract, agreement, clause, covenant, waiver, or other document. And in my world, what that includes is, like I said, employment agreements, settlement agreements, severance agreements, termination agreements, and arbitration agreements. Some of those are kind of the same, some are not. You don't see too many arbitration agreements, actually. So what this amendment does is it voids any employment contract, which again, severance, whatever, that requires an employee to waive or arbitrate claims regarding unlawful employment practices. So this is an expansion of the law. And what I mean by that is it used to primarily apply to discrimination, harassment, and retaliation. So the specific wording of it, I don't remember exactly what it was, but it was clear that it was really more human rights violations that you couldn't have waived or arbitrated. Now it includes any unlawful practice actionable under state or federal employment law. So what does that mean in common sense words? Wage claims you now have to deal with. Unemployment claims you now have to deal with. Basically, anything an employee could sue a company for under the sun that's by statute in Illinois or federal law now covers this. So you can't have anybody agree to waive or arbitrate those claims now, unless, and I'll come to it, I guess, in a couple minutes here. And the other thing that they added, you can't shorten the statute of limitations. So in other words, if the statute of limitations on a wage claim is 5 years, you can't say that you have to bring your claim within 2 years. I think the Department of Human Rights is 300 days. You couldn't shorten that. Anything else that might be applicable, you can't shorten those either. You can't have an agreement that says you're going to use Colorado law on Illinois claims. So if you had a Illinois employee or an Illinois company and you decide that the law of Florida is more favorable to you as an employer, you can't say this contract will be interpreted by Florida law. Can't set venue out of state if it's prejudicial to the employee, which in most cases is going to almost always be the case, unless it's right next door to us, Wisconsin, Indiana. Has to be in writing with actual consideration and let employee report unlawful conduct. So this is kind of the exception to the rule. What I mean by that is you can shorten the statute of limitations. You can apply out of state Illinois law. You can set venue out of state, but you have to pay the person for it. Actual consideration. What is that? The story they always tell us in law school is that consideration can be peppercorn. It's always the example they use. My experience is it can be nominal. It doesn't have to be a huge sum of money. but it's got to be in there. And you actually have to give them the money. So on the first paycheck or something, for you to write a separate check. So you can do any of these things if we pay them. If you don't pay them, you cannot do any of those things. And then the one thing that hasn't changed at all, you have to continue to let them report unlawful conduct. What that essentially means is they could still report something bad that happened to them. They just can't financially recover. You have to let them report if the company's doing something bad. You have to let them report if another employee is being mistreated. There's no way to weigh that on that. Confidentiality provisions must also be obtained with consideration. Very slight subtle change on this. So the way a lot of agreements used to read would be confidentiality is the documented preference of the parties. And so as long as you had that in there, the agreement was fine and they had to keep it confidential. Now you all actually have to also pay them for the confidentiality provision. So that provision might read something like, in exchange for the parties, avoid keeping this agreement confidential, we'll give you $1, whatever the number is. And then it's increased damages, so consequential damages in addition to attorney's fees and costs that were previously available. So consequential damages are damages that are reasonably foreseeable to a party. So if you fire somebody, it's reasonably foreseeable they're not going to be able to get a job the next day. And then that expands a little bit. There's other different kinds of consequential damages that can arise. How many of you guys are familiar with unions or run across them? Just out of curiosity. It does provide additional protections for employees engaging in concerted activity to address work-related issues by preventing the prohibition or restriction of employees to engage in concerted activity. What does that gobbledygook actually mean? In the union context, and this is not really a union provision itself because there's laws for that, but in the union concept, concerted activity is employees talking about wages, benefits, conditions of employment. In a union context, it's where they're forming a union or maybe in a union. So this is a little bit different. You might have employees that just talk on Facebook or in the office or any of those things. You can't retaliate against them for engaging in that quote-unquote concerted activity, but concerted activity being them kind of getting together to do things. Any questions about that 7 things? All right, so the Illinois Human Rights Act was amended in 2 parts. One's kind of more important for HR people. The other one's more about back-end legal issue that Sarah and I deal with. So employers are now required to provide notice they're using artificial intelligence with respect to recruitment, hiring, promotion, renewal of employment, discipline, discharge, or other terms and conditions of employment. Obviously, this is kind of a hot thing right now with all the artificial intelligence stuff going on. I'm sure companies are using it. I don't know how specifically. There's HR people in here. I'm sure you guys have a better sense of that than I do. But now you have to provide notice to people if you're using this and somewhat how you're using it. Penalties for non-compliance range from $500 to $10,000. They're based on company size primarily, usually, and if you're a repeat offender. So how does the Illinois Human Rights Act define AI? The machine-based system that for explicit or implicit objectives infers from the input it receives how to generate output such as predictions, content, recommendations, or decisions that can influence physical or virtual environments. So, example, there's actually a great commercial for this for football where the guy's at the scouting combine and he puts in all this information for a linebacker where he's like, okay, this guy, and I want the guy that's 6'2", runs a sub 4.75 40, had 90 plus tackles in college, and then it has leadership skills. Which guy? And it picks the guy up. So similar, if you put in some kind of function like that for employees and spit it out, you'd be using AI. It also applies to generative artificial intelligence, which is, I'm not real tech savvy, but it's more if you put in something and wanted it to generate an image or output something, written material, photographs, that's generative. Yeah, I'm not an expert in that, so I wouldn't really know how an HR person would use that. I could definitely see an HR person in the first part, yeah. So, what to do? Well, it prohibits an employer from using AI where it has the effect of subjecting employees to discrimination on the basis of protected classes under the IHR. Protected classes, age, sex, gender. In Illinois, it's actually a pretty long list. It's longer than it is for federal law. How would you do that? Show me only Hispanic women under the age of 40 that live within 5 miles of my location. That would clearly be discriminatory. If you just put in, show me every candidate within 5 miles that did this, that, or the other thing, or whatever it is for specifically you're looking for. You got 5,000 resumes and you ask the AI to go through and show me every person that has over 5 years experience working with this particular software and they've been at a law firm 2 years of the past 5. That would be discriminatory. That's really just kind of how you use it. Now, this being the state of Illinois, they passed the law but didn't put the rules in place yet. So there are proposed rules right now. They're not even open for public comment yet, which means your big industry groups haven't chimed in on how these are going to affect them. The big thing with this particular act is the notice provision, right? Telling people, potential applicants that you're using AI. They haven't come out yet with what that notice is supposed to look like. So good luck to everybody. However, employers are expected to make a good faith effort to comply with the law. What does that look like? I mean, we use AI. I don't know that you have to get into a real detailed notice. And as the rules come out, this will become a little bit clearer for employers. The rule-making process, they come out with some ideas and then industry groups chime in with kind of how this could be bad for them and the rules change. So we're not there yet. I don't think we'll even see it till this year because the public comment period isn't even open yet. So I think that's a 90-day period if I'm not mistaken. So probably not going to see that for a while. On the back end of things, the change that's kind of just for lawyers, a new amendment specifies that the Department of Human Rights will not automatically conduct fact-finding conferences. So without boring you to death, person filed a discrimination claim. Generally, the Department of Human Rights will have a fact-finding conference. So what that means is they'll kind of get on the phone with the person and with the employer and kind of flesh out the facts. Now they'll only do the fact-finding conference if the parties request one within 90 days of the charge being filed. And they also agree to extend the investigation by 120 days. Conceptually, I kind of know why this was in place. They're backlogged. Every person... Most people today don't feel like they get terminated because they did a bad job. They feel like they were terminated because there was some other reason. And so the Department of Human Rights gets a lot of claims. And by statute, they have to conduct the investigation within a certain amount of time. They are not able to do that anymore. Every case I've had with them in the last 2 years, I've been asked to extend the investigation time because they're so jammed. So they cut that out. I'm on the fence about whether this is a good or bad thing, honestly. Sarah's done fact-finding conferences. I'd had them absolutely blow apart for the person that's bringing the claim. So sometimes they're fantastic because the person kind of just falls on the sword and then it ends there. The downside is you can have a fact-finding conference, and if there's a disagreement as to the facts between the two parties, the case automatically moves forward. So you kind of lose the ability at that point to maybe just have it dismissed, which can be good. So we'll got to see it. To me, it's always been a case by case thing of whether I would want a fact finding conference. I feel a person's case is weak or their claim is bad. I'd love to have one. If I think their case is decent, I'd rather just cut to the chase. Then this amendment was actually Sarah and I were talking about this one. So the Victims Economic Security and Safety Act, VESA, is it's more commonly known as VEME. For those of you who don't know, this is kind of FMLA for victims and their families of domestic violence. And so what the statute itself provides for is unpaid time off for victims and their family members of domestic violence. Similar to FMLA, it's got job protections and other things of that nature. The amendments that they made prohibit employers from retaliating against employees or withholding employer-issued equipment because that equipment was used to document domestic or sexual violence against the employer, family, or household member. Like I was telling Sarah, sometimes when I look at why a law changes, I always have to wonder what happened that kind of got you to that point. And so the only thing I can guess here is that there were employees that would use a company issued phone or a company issued laptop and were somehow documenting on that business equipment domestic or sexual violence. And then when it came around to the employer is then dragged into that whole investigation and everything because it's business owned equipment. And then they fire the employee because they're being dragged into this mess. So that is my educated guess as to how this amendment came to pass. I don't know if it's factual or not. The bottom one, it requires employers to provide employees access to relevant recordings or digital materials on those devices. So somebody records something on their company cell phone and they resign the next day. And you have them turn their phone in and this thing is recorded on there. You're going to have to give the employee access to it. It's almost kind of very loosely, almost like their personnel file. You have to provide them access to it. So that's an interesting change. The act itself doesn't really deal with this. So it's kind of an interesting spot for it, but there you have it. And I think, Sarah, you're off.
My insight reflection. Sure. On that very last one, as not only am I HR, but I'm IT. So somebody. I go to therapy once a week. Somebody turns in their phone and I have absolutely no idea that this thing's recorded. 9 times out of 10, I'm wiping that phone tomorrow just because I'm going to replenish it to someone else. What happens if I had no idea something was on me on that phone? No. Okay. I don't have to retain it for a certain period of time to possibly have, but
If you don't know about it, no. I mean,
You don't know any litigations on their
yeah, I mean, usually a common practice that I have when I litigate is, and you know this probably better than anybody in this room. Part of my world mostly used to deal in paper. Now it very much deals in what's called electronically stored information, emails, text messages, images. And normally, what I'll see or do is if there's litigation imminent, I'll get a letter from an attorney that says, hey, we have this claim against Joe Smith, and you are now in order to hold all your destruction protocols and keep all the evidence that you might have about this. Absent having that or not knowing, you know what I mean, you're just doing your job and you're following whatever security protocols you as a company or an HR person have. So there's no, there shouldn't be any liability. What are you going to do? I mean, I didn't even know it was there. And I wiped the whole phone. And every time an employee quits, I wipe the whole phone. So we should be safe on that one.
could still raise this, but that's your defense. well, a lot of this is about me. To Lance's point, Illinois is a very employee-friendly state, so a lot of the times it is so easy to put in the check a box and file a discrimination claim, but it's about what can we do as your attorney on the employer side to mitigate, the risks and mitigate the damage at that point, and try and just develop the best defense. Any other questions on any of those topics? All right. I guess I didn't introduce myself yet. I'm Sarah Ruche. I work with Lance frequently in litigation. We deal with anything from employment litigation to large business disputes, mostly commercial litigation, and also some individual litigation as well. So I have a background in dealership law, but it's also a little bit of a niche industry that I started my career with, and we still represent dealers today. And that kind of applies to a lot of the commercial litigation work I do too. So yeah, today I'm going to focus back on the employment laws. And this one's really interesting. Also like personal to me. Many of you might not know, but Illinois is one of the few states that mandates fertility coverage for certain employers. Wisconsin does not, for example. What does this mean? Well, in 2024, Illinois enacted something called the Public Act 103-751. And what that did is it amended the Illinois Insurance Code to address infertility coverage in group health plans. Until December 31st of 2025, the group insurance policies, any group insurance policy in the state that provided pregnancy-related benefits needed to also cover infertility diagnosis and treatment. That includes things like in vitro fertilization, embryo transfers, artificial insemination, and like anything in between. So basically, once somebody starts going to a fertility clinic, the group insurance plan needed to cover it. But until last year, the end of last year, this only applied to insurance plans that had coverage for more than 25 employees. Now, that 25 employee limit is lifted. So group health insurance plans offered to employees in Illinois must cover infertility benefits regardless of the number of employees. And this was first a state employee thing, but based on our research and preparing for this, it appears to be a public and private sector requirement now. It's in the Illinois Insurance Code. So, this is something to be aware of. A lot of companies already offer it. Blue Cross Blue Shield PPO already covers this. So if your company is offering that to employees in a group health plan, you're good. I can't speak to any others. Good. A lot already are offering this. And it's something to be aware of that, if you aren't yet, take a look at your policies, consult your benefits provider, and have that conversation. It also does a couple other things. This Group Insurance Act expands coverage for peripheral artery disease screening for those at risk and covers annual menopause visits for individuals 55 or over. That requirement, from what I can tell right now, is still on the 25 employee or more threshold. So they introduced these things kind of in a tiered approach. So for the menopause visits, if it's a group health plan offered to 25 or more employees, that's when you need to provide coverage for those visits in the group health plan. I would imagine, like the fertility coverage, the coverage for menopause visits, likely the 25 employee limit will be lifted after some time, like the fertility coverage was. Moving on to the Family Neonatal Intensive Care Act. This is the one that Lance mentioned is not in effect yet, but will be in effect June 1st, 2026. So you've got some time to prepare if you haven't thought about this or hasn't crossed your desk yet. Again, might be something to talk to a benefits provider about and consider, obtaining a separate form for when an employee elects to take this unpaid leave. What the act requires is that if you're an employer with 16 to 50 employees, you need to provide 10 days of unpaid leave when an employee's child is in neonatal intensive care. If you're an employer with 51 or more employees, instead of 10, it has to be 20 days. And similar to FMLA, right, this can be taken continually or intermittently 2 hours at a time. If a baby in the NICU, needs just maybe some parental visits for 2 hours, that's where they can take advantage of this act and it is unpaid leave. But importantly, you can't retaliate against an employee for using it, right? You can't say, well, Sarah was gone, virtually all of last week, and I need her to be, on this case. Like, we're just going to let her go because this isn't working out anymore. Now it's a clear retaliation for the protected activity that I'm engaging in under this act. It also can't require them to use paid leave for these things. They are electing this, to engage in their protections under this act to visit the NICU with their baby. You can't require them to take PTO to do that. And afterwards, after they've taken that leave, they do need to be reinstated to their former position or something that is substantially equivalent at the end of that leave. So, don't demote them after they come back. That's still going to be a violation of the act. All right, my last one for today to talk about is the Nursing Mothers in the Workplace Act. How many of you have heard of this act? Okay, it has been in effect, so good seeing some hands. It was in effect, and really what the change is this year is clarifying that the breaks that you need to give to a nursing mother to express milk for an infant child need to be paid breaks. You cannot require them to take paid leave. Again, you can't say take PTO for that and that's all good. No, they have to be paid breaks regardless of logging that as PTO, and you can't reduce their compensation during that time. Say, okay, well, since you're not doing any work during this time that you're expressing milk for breastfeeding purposes, then your pay is going to be half the pay while you're doing that. No, it's got to be full pay. Can't reduce their compensation for doing it. Can't retaliate against them for doing it. Needs to be full regular rate of pay. There is a caveat, like any employment, like most, I guess I should say most employment laws. If an employer can prove that it's undue hardship, that it places an undue hardship on them to continue to pay an employee expressing milk while they're breastfeeding, then maybe you have a shot at a defense here. But the undue hardship standard is high. It has to be prohibitively expensive or disruptive when considered in light of specific factors, including financial resources of the employer, the size of the employer, and the impact on operations. So in general, it's recommended just comply with the law, allow them to take these breaks. I believe it's for up to 1 year while they have an infant child. And this does apply to all employers with more than 5 employees. So I guess if you're in this room and you have less than 5 employees, you don't need to do this. But most do have 1 in 5 employees. So definitely something to know about. All right, passing back to you, man.
Yeah, I told you it's been kind of easy. They end up like really slam dunked anything that I kind of like want. So the Employee Blood and Organ Donation Leave Act, the amendment is it permits part-time workers to use up to 10 days of leave in any 12-month period to serve being an organ donor. This used to only apply to full-time employees, so that's kind of the change there. How you pay the employee, if it's a full-time employee, you just pay them their regular wage. If it's a part-time person, you have to use the daily average of their wages for the previous 2 months. So that gives you a little more flexibility as opposed to a full-time person. Didn't even know this thing existed until I looked this up for this. So, Service Member Employment and Reemployment Rights Act. This is an Illinois specific law. There is a federal law that also covers this. The change here is that service members' employment is interrupted by a period of active service can use vacation or paid time off to cover this time period. It's a little odd to me that wasn't the case before. I think under federal law that is the case, so maybe there's catching up that way. The caveat there is the employer cannot require a service member to use this time, so it's at the service member's option. Wow, you guys are going to be out of here early. But again, this year was kind of a soft year, in my opinion. Things that they put in place were really changes to existing laws, amendments to existing laws, which, in my world are a lot easier to deal with than some of the things that's come out in the last 6 years. We had non-competes, complete new laws, the Workplace Transparency Act, complete new law. A lot of these things changed and really affected employers in terms of how they would draft agreements and deal with certain things. Again, this year kind of like just kind of, to me, kind of cleaning up. Questions. That's can cover a pretty broad range of topics since I'm hopefully educated.
Yes, I have a question for Sarah about and stuff. Is there like what is the law that we have a new employee who's like pregnant and he's already talking about his paternity leave?
Yeah. My understanding, I mean, I'll look to you, but my understanding is that's just an employer decision at that point. There is no specific state law that requires any sort of leave for fathers.
There's actually no state or federal law that requires paternity leave. That's completely a player. A lot of the laws that deal with pregnancy discrimination and like the nursing mothers, natal type act, those are specific in terms of what they're addressing. But for a broad-based type thing like that, there's no state or federal law that mandates that at all. So there's no law that says dads get 5 days and fathers get 10.
So we would let him use his vacation time, sure, but given time without pay.
Or FMLA.
Right, FMLA. Okay.
Yeah. FMLA would be unpaid for that in 12 weeks, right? And it could be all unpaid.
Okay.
Yeah.
Thank you so much.
Yeah.
But let's be careful with the FMLA though.
Okay.
FMLA is a little more specific in terms of how you can use it.
Like more like if something's wrong with the baby or the like if there's issues.
Yes, and your FMLA is more set up that if I have to undergo a medical procedure, I've been out of work for some period of time, I could avail that myself of that. But then when you start talking about family members, then is there a caregiver role you have to get there that triggers that somehow? But just I think from a standpoint, though, and I'll be honest, I didn't even think about it, but from a standpoint of I'm just going to take FMLA leave because my wife had a child. I'm dad twice, so they'll take time, but I don't know that would necessarily be the leading colored when you have a particular situation. And then the other issue you have is a lot of handbooks and stuff I do for smaller companies have unpaid leave provisions, which is a good example of using something like that. The difference you have is FMLA, you now have job protection status, whereas in a unpaid leave of absence, you may or may not have that in how the company structure.
But the Neonatal Intensive Care Act, I believe, applies to both parents.
It does.
Yeah. So that could be,
So if there's something wrong with the baby, then we'd have to put it differently.
yes. Then you have to think about, they have to be able to take unpaid leave in addition to that FMLA to be with that baby at the too, even if it's a father.
Thank you. General next question on infertility. Does that cover self-insured plans or global insured plans?
Fast. I was going to think about you. If you get into the law for the reason I say that is just because when you look at any statute, and especially, so your original thought when you look this through the state employees, right? So that's a very somewhat narrow subset of people. When you start talking about amending the insurance code, I've had the unfortunate experience of going into the insurance code. Definitions become very important. So self-insured plans, when they say this particular thing, and I would look at us specifically to answer the question, then they say any group plan, or it may say any, let's say it's group plan. Okay, well then what's a group plan? Well, group plan includes self-insured and non-self-insured, or it might not include that in that definition. So I wouldn't want to sit up here and opine on that because I really want to look at the definition before I gave you an answer to that question.
Yeah. You could question for insurance person as well.
Yeah, I mean, I'm a broker, so I can just chime in. So my understanding is that applies to fully insured plans. Self-insured plans are subject to ERISA, so there could be exclusions there. Even though most employers probably offer that as a benefit, but there can be an exception for self-insured at a high level. The ERISA component.
Anybody else?
Yeah, no crazy groundbreaking thing.
Well, if you guys have any questions or something you want to just kind of really privately do the in around, otherwise, please enjoy the rest of your day. And if you have questions, our cards are up here.